to ensure neutrality and impartiality.
The Honourable David Parker.
Mr Chairman, can I first respond to something that the Green Party said? You know, it's actually wrong to say that except in respect of production and examination orders, this bill doesn't extend Crown powers. And for the Green Party to stand here and tell New Zealanders that it does is wrong, because it actually undermines public confidence in important democratic institutions, including the police. So please don't make wrong accusations in respect of what I think is important law. You can say that you don't think they should have those powers anyway, and that therefore they shouldn't be carried forward, but please don't pretend that these are new powers except in respect of the powers of examination orders and production orders in respect of the police. Everything else is a carryover, and indeed there are areas in which powers are being constrained that weren't previously constrained, and the police gave up some of those powers. One example was at the moment the police, when they pull over a vehicle, have got a right to search the vehicle even if they were pulling them over for a traffic offence. And that's wrong. You shouldn't have unreasonable search of surveillance on the police going on a fishing expedition for a car. If my memory serves me right, the Minister will correct me on this one, but my recollection is the police gave up that power that they've currently got because they thought it wasn't appropriate. And they agreed with the Select Committee that it wasn't appropriate. Where we have reached, and there's one other general thing I will say, and that is that there are currently powers that have until we were at Select Committee, we were told that there were new technologies pursuant to which search and surveillance powers were being exercised, where the advice we had at Select Committee was the use of those powers was unregulated because they were not covered by old search and surveillance laws which were promulgated or passed by this Parliament before those new technologies came along. Now, between that time and now, we've had the Harmad decision of the Supreme Court that said the advice that we were getting from officials was wrong, and that in the absence of specific statutory authority, the exercise of those new technologies was illegal. But what the process threw up was that there are new technologies that I think everyone in this House agrees should at times be available to the police, which are, for example, video surveillance technologies, and the example that was used at Select Committee by the Law Commission, who were in favour of the extension of this power to the police, was in respect of drug syndicates who draw the blinds and do not talk when they are describing where they're going to distribute their drugs. And the only way that the police can get evidence of that activity is through video surveillance, and that video surveillance technology was a form of technology that wasn't properly covered by prior technology. So you either don't have these powers at all, or you have them and you regulate them properly so as to safeguard civil liberties, to protect the public from inappropriate intrusions by state agencies into their privacy. And what this bill tries to do is get that balance right between those two competing objectives. And I would like to thank the Select Committee, Chester Burrows, who I thought was a very, very good chair. He brought the experience of policing as well as his legal experience as a lawyer, plus his experience in life. And together with other members of the Select Committee, we actually sorted through a very, very complex series of issues. We actually went to the extent of producing another draft of the bill because it was so complex that we thought we should put it out to a second round of consultation after we fixed up some of the errors or some of the things that were of particular concern to submitters, because you don't want people having unnecessary concerns that the state's getting unwise powers of search and surveillance. So I would thank the government for that, but there is one glaring issue in this, and all of these pious talks about how we're rationalising the powers of search and surveillance for all agencies. Well, we are generally for the police and most other agencies, not for the Security Intelligence Service, which has got separate legislation which was tidied up last year. And the other glaring anomaly is the Serious Fraud Office. And the Serious Fraud Office has got broader powers than any other state agency. They don't have to get a warrant to exercise their powers to issue a production order or an examination order.
Sorry to interrupt the honourable member. The time has come for the dinner break. This debate's interrupted. I shall resume the chair at 7:30.